Hello, I'm Stuart Hill, Acting First Minister of the Sovereign State of Forvik and the Sovereign Nation of Shetland. I'm talking about Allodial Title and how it gives us the potential to take us into a world of abundance, peace and joy. So, nothing too ambitious. I live in Shetland, which is almost universally regarded as part of Scotland and the UK, but the purpose of the Sovereign Nation of Shetland is to challenge the UK and Scottish governments to show how they derive their authority here. For those of you who don't know, Shetland is the northernmost part of the British Isles. We're right out in the Atlantic, and our nearest railway station is Bergen in Norway, which is appropriate because Shetland used to be part of Norway, and its original and never removed legal system was the old Norse feudal law, the fundamental tenet of which was Allodial Title. So there could be no better place to study Allodial Title than Shetland. It underpins everything here, but the authorities would much prefer that you don't mention it. There's a universal presumption that Shetland is part of Scotland, but that's all it is, a presumption. I've been working on discovering how Scotland and the UK derive their authority in Shetland since 2002, and much of that work has come to be centred around the question of Allodial Title. I don't claim to be an expert, but I have made challenges at every level in the Scottish court system, as high as the Supreme Court. For any Scottish court to have jurisdiction here, Shetland must be part of Scotland, but no court has been shown any proof. The best evidence the Crown has come up with is a magazine article by our local archivist, which contains not a shred of proof. In their exasperation when I don't go away, judges have put me in jail twice when I've challenged their jurisdiction. And bail conditions on a current case even forbid me from challenging the jurisdiction of the court, which of course is my fundamental right. I've found judges at every level ready to break the law and ignore the legislation and their own rules in their efforts to avoid the issue. The more extreme methods they adopt, the closer I am to a breakthrough. So, although I'm going to talk about Allodial Title, it's from the perspective of somebody untrained in legal matters and somebody who simply follows his nose without the preconceptions and baggage of a trained legal mind. Having no knowledge of the Scottish court system made it hard at first, but has turned into a positive advantage. I've always said, if you don't know what you can't do, there's no limit to what you can. My lack of knowledge often means that I'm asking about things the lawyers take for granted and could never question since they're part of the system. What I'm saying is meant for those countries around the world that used to be part of the British Empire. It may well apply in other countries, but I've not made sufficient study, so I can't say. Legal systems in the colonies generally developed from English law, so I need to give you some background on that. Something that must be understood from the start is the difference between feudal title and allodial title in English law. So I'll start with some observations on feudal title. That'll give you a perspective on how landership is viewed from the top, as it were. Feudal title, however it might be packaged, is universally used in those countries whose laws derive from English law. The underlying premise is that the ultimate title belongs to the king or queen or to the state and can't be touched by the normal citizen. In England, the king owned all the land in the realm, and by means of feudal charters he'd granted out in large chunks in exchange for service or obligation to any favoured courtier, who in turn would let it out to those he himself wished to reward or place under obligation. Ultimate ownership, the allod, was never released by the king. All those under him were in the nature of tenants or subtenants. The terms fee simple and freehold are terms used to describe the feudal title, and as soon as you see the words fee, few, feud, freehold, seisin, and many others in title deeds, you know that the title is in the feudal system and the relationship is one of owner and tenant. There's some degree of confusion in the legal dictionaries and law books as to the nature of the ultimate title. For instance, West's Encyclopedia of American Law, edition 2, defines fee simple as, and I quote, the greatest possible estate in land, wherein the owner has the right to use it, exclusively possess it, commit waste upon it, dispose of it by deed or will, and take its fruits. A fee simple represents absolute ownership of land, and therefore the owner may do whatever he chooses with the land. If an owner of a fee simple dies intestate, the land will descend to the heirs." Unquote. Notice it says, "A fee simple represents absolute ownership of land." It doesn't, and I'll be explaining why in a minute, but this shows the difficulty lawyers have with the concept. Although the medieval feudal society concepts of lord and vassal have long vanished from the surface of today's society, those concepts are alive and kicking in the legal world, and especially the landholding system in English law. The assumption in English law is that the highest title available to subjects is freehold or fee simple. However, freehold, or freehold tenure to give it its full name, is not ownership but holding under the Crown. While in England most people think they own their own land, that is not so in any legal sense. All land is deemed to be owned under the Crown, and the only person able to actually own land outright is the Queen. This is what Halsbury's Laws of England says on the subject. I quote again. Technically, land is not the subject of absolute ownership, but of tenure. According to the doctrines of the common law, there is no land in England in the hands of a subject which is not held of some lord by some service and for some estate. This tenure is either under the Crown directly, or under some main, and that's spelled M-E-S-N-E, and means intermediate, under some main lord or a succession of main lords, who, or the first of whom, holds of the Crown. Thus, the monarch is lord paramount, either mediate or immediate, of all land within the realm. The tenure of land is based upon the assumption that it was originally granted as a feud. That's what I referred to earlier as a feudal oh, it's gone. Anyway, originally granted as a feud by the monarch to his immediate tenant on condition of certain services, and where there has been sub-infeudation, that the immediate tenant in turn re-granted it. Although for most purposes this system, known as the feudal system, has lost its practical importance, it still determines the form of property in land. Unquote. So, for all intents and purposes within the current system, a feudal title, freehold or fee simple, is the highest title available to any subject or citizen, but it's only a holding under the Crown. Notice also that in the last quote that Halsbury says, "There is no land in England in the hands of a subject which is not held of some lord by some service and for some estate." In an Australian case in 1975, Judge Jacobs said, and I quote, unless under another sovereign, a subject of the English Crown could not own land except of that Crown, because if he could, he would be sovereign of that land." Unquote. So if you own the allodial title, you are sovereign of the land. The allodial title is always held by the Crown, so it's of no interest to mere subjects or citizens. Allodial title is the real ultimate title in land. It means absolute ownership, free from any lord or superior. It's land owned in the same way as a piece of jewellery, furniture, or any personal possession might be owned. It's an ancient right, going back to the days before there was any written law. It's absolute. Black's 4th edition defines it thus, and I quote again, "Free, not holden of any lord or superior, owned without obligation of vassalage or fealty, the opposite of feudal." Here in Shetland, the term eudal is often used. It means exactly the same as allodial, and here again is what Black's 4th edition says on eudal. A term mentioned by Blackstone as used in Finland and incidentally in other Scandinavian countries to denote that right of in real property, which is called in English law allodial. The Sazines Manual, which instructs those involved with land registration in Scotland, states, and I quote again, "The nature of feudal tenure," I'll come back to that phrase, "is that it's allodial. A feudal landowner holds absolute title, free of any interest of the Crown or any intervening superior." That phrase, feudal tenure, once again illustrates the difficulty lawyers have with this concept. Tenure implies a right from a higher party, whereas the very nature of allodial title is that of allowing no lord or superior. So feudal tenure is an oxymoron, but this and other such phrases are sometimes used in an attempt to gloss over the fact that holders of allodial title have no lord or superior and cannot be fitted into the English legal system. If you have a true allodial title, you are automatically sovereign over that land and you have your own jurisdiction. Feudal law was a complete body of law. It's never been taken away in Shetland, only supplanted by Scots law as more and more Scottish dignitaries arrived, bringing Scots feudal law with them. But even today, feudal law trumps Scots law in any land dispute. And interestingly, the Crown makes no ultimate claim to any land or foreshore in Shetland. The whole of Shetland is allodial, and a Shetland homeowner or anyone legitimately owning a piece of land is above the Queen, if they can ever believe it or get their head around it. Feudal law predates any written law, but was written into the first written Norse laws. Fundamental to feudal law was the concept that every landowner owned his land outright under God. He had no lord or superior, and those people elected their king from among their number. In Shetland they made their own laws, and they had their own parliament. I can think of no more complete definition of individual sovereignty than that. I'm not going to go into Shetland's history here. That's all covered in my book Stolen Isles, which you can find at stolenisles.com, and there's a note below. Suffice it to say that the rights of our 15th century landowners have been passed down undiminished to their descendants, everyone who legitimately owns a house or land in Shetland. I say legitimately because there are large estates here set up on the basis of feudal charters issued by kings who didn't own the land in question. Those major landowners now find themselves sitting on very dodgy titles, another reason why the establishment doesn't want us to know about allodial title. In the meantime, the incoming Scots, armed with feudal charters granted by a king who didn't own the land he was granting charters on, conned the local people into thinking that without a piece of paper their land was worthless. Allodial title has never been abolished here, but Scots law prevails as the commonly used law, and all land sales are done in feudal form by lawyers trained in the Scottish system. That in itself cannot convert the allodial titles to feudal, so the lawyers are left with a problem that once again they would rather not discuss. With allodial title comes sovereignty, and with sovereignty comes jurisdiction. If you have a allodial title, you cannot be part of any other realm. That is why allodial title has no place in English law. If you have allodial title, you cannot be part of the realm of England. Your title will be in conflict with the deemed title of the Queen. The entirety of English law exists in those layers below the allodial title, the feudal realm. The Queen's ultimate allodial title is never affected by any commercial considerations. If somebody defaults on their mortgage and the bank repossesses the house before selling it again, it's of absolutely no concern to the Queen. Her title remains serene, untouched, and untouchable. So it is with any allodial title. Yet another reason the lawyers are so touchy about it, and generally will not even admit that allodial titles exist. They're right, of course. Allodial title doesn't exist within English law, but that's not to say it doesn't exist outside it. Allodial title is the ultimate title in land, as I said, and nothing trumps it. There can be no form of qualified allodial title. like pregnancy, you can't have a land title that's a little bit allodial. Allodial title is somewhat inconvenient for lawyers and heads of state because it brings with it innate sovereignty and jurisdiction. If you claim allodial title, you cannot claim to be part of any other country. To get round this difficulty and explain it away, lawyers will use terms that disguise the absolute nature of allodial title. I'm aware that in America the very idea of a feudal relationship between the administration and the people is anathema, and some states claim to grant limited forms of allodial title subject to conditions such as expiry on the death of the holder and so on. There can be no conditions placed on genuine allodial title, and in my view there are no genuine allodial titles within the American system. The Fifth Amendment precludes genuine allodial title when it speaks of eminent domain, the right to take private land for public use. By claiming that right, Uncle Sam steps into the Queen's shoes as the ultimate allodial title holder. Anyone doubting the position of the state should refer to Senate document number 43, Senate resolution number 62, page 9, paragraph 3 of April the 17th, 1933. It says, and I quote, "The ultimate ownership of all property is in the state. Individual so-called ownership is only by virtue of government, i.e. law, amounting to mere user, and use must be in accordance with law and subordinate to the necessities of the state." Unquote. So this is the land of the free. Claiming allodial title puts the onus of proof onto those who presume to own it, the Crown and the state. In Shetland it's relatively easy because the history shows it was never taken away from the people, and nobody can show a date or document when the Scottish or British Crown gained ownership. But even here the presumption is so strong and has been in place for so many years that it's difficult for people to think there could be any other way. The government couldn't possibly have cheated us to that extent, could they? Well, it's taken over 500 years and much has been buried, but yes, they could. Exactly the same kind of deception happened in all the colonies. The British were there for one purpose only, to get whatever they could and maximise profits while doing it. Any so-called treaties were simply window dressing, couched in terms advantageous to the British and of course to be interpreted in English law by English lawyers. I'm going to say a few words about our existing system. Although I've been talking about allodial titles in land, exactly the same applies to each one of us as individuals. Unless we abandon the allodial title to our bodies, we have absolute sovereignty over our own bodies, minds and souls. The existing system ensures that we abandon that at birth, so we need to reclaim it. We don't need to know the mechanics about how it happened. We don't need to go into and understand their system in order to reclaim our birthright. All we have to know is that whatever was done was without our knowledge and was therefore fraudulent. Fraud vitiates all contracts. End of story. In contrast to the existing corrupt system where complexity is used to confound us at every turn and where we are made to be dependent on experts to understand it for us, a system based on allodial title starts with the simplest of concepts. Allodial title means absolute ownership, period. Any new society needs to take account of individual sovereignty. Whereas the existing system, whether we know it or not, is based on the feudal model and designed to concentrate its wealth in the hands of a few, any just society must have it at its heart the sovereignty of the individual. This world of abundance, in which artificial scarcity is used by those in power to keep the rest of us under control, will be opened up to give everyone access to that abundance. Paradoxically, that will also be to the advantage of the current elite. A system reliant on constant and exponential growth is unsustainable and is bound to collapse, as we can see today. A society honouring individual sovereignty, the allodial title of everyone, is sustainable and will take us into that world of abundance. So, how do we get from here to there? Although the concept is simple, that doesn't mean to say it'll be easy. TPTW, the powers that were, will fight tooth and nail to retain their power, even though the current system is doomed to fail. If we look upon this change as a fight, we can only delay its progress. We're looking for a way to peacefully and without conflict simply turn our backs on the existing system and start a new one. Just like leaving the Model Railway Club and joining the Stamp Collecting Society. Those who wish to remain can do so, but when they see the benefits of this new society, everyone will want to join and the old system will die on the vine. The most powerful weapon for those opposing me when I started was ignoring me. We can turn that weapon back on them. Many people spend their time finding out all the nasty details and exposing them for all to see. For me, it's only necessary to know it's happened. I don't want all the gory details. Fighting the system only validates it and it increases its power. Ignoring it and removing our support makes it weaker. Just stop feeding the beast. Many people have mortgages, and while I believe that honouring one's contracts is essential, fraud vitiates all contracts, as I said before, and every bank mortgage is fraudulent. It won't take much research to convince you of that if you're not already aware. Allodial Title pulls the rug from under any mortgage. Going back to the situation in England, the Queen owns the allodial title to the whole realm, allegedly. If someone defaults on their mortgage, it never affects the Queen's ultimate title. Her title remains serene and supreme above everything else. Allodial title allows of no lord or superior. With it comes sovereignty, and with sovereignty comes jurisdiction. By claiming allodial title, you are claiming something that is superior to anything in law. Mortgages and that kind of commercial activity remain in the layers below allodial title. I live by two maxims, one of which is, whatever's happening right now is just perfect. In that knowledge, I know that everything is on the right track. Those times when things look at their worst are usually the times when there's about to be a major breakthrough. I've just got used to, having done the best I can do, sitting back and watching as things unfold. Often I'm taken by surprise at the way they unfold, but it's always for the better. My other maxim is, we act as a magnet for the thoughts in our head. We're conditioned to have muddled thinking, but as soon as you start to organise your thoughts, the thoughts you hold constantly are the ones that start to attract people and events to further your goals. Those who would control us don't want clear thinkers, so we're fed a diet of game shows, sitcoms, soaps, news on TV, anything to dull any clarity or critical thinking and divert our attention. We're conditioned to be dependent on government, corporations, religious leaders and anyone who wants power over us. But there's a lot more of us than there are of them. My view is that we're on the brink of a major shift into a world of available abundance. I say available abundance because the world is already abundant, but we've been conditioned to believe we're in scarcity because the abundance has been cornered by a few. Nothing shakes my belief that the shift will come at such a speed that we'll all be taken by surprise. As the Indians say, we are the ones we've been waiting for. As for the process, I believe simplicity is the key. The more complicated we make it, the more opportunity we offer to be tripped up by clever lawyers. I'm reminded of the first time I challenged the jurisdiction of a court here on the basis that Shetland is not part of Scotland. The judge immediately asked me, "Is there anything else, Mr. Hill?" What else could there be? With that simple concept, I was challenging his whole existence. He wanted a complicated argument he could get his teeth into, but the simplicity floored him. So simple, straightforward. We stake our claim and ask if anyone thinks they have superior one, let them bring it forward. Otherwise our claim stands. In Shetland, I've made a claim for the allodial title for the land and surrounding seabed on behalf of the sovereign people of Shetland. That claim is not challenged by either the Scottish or the UK governments. They've been given the opportunity to rebut it, but have chosen not to do so. They're now subject to rules which prevent their future denial. So, to recap, allodial title as a concept is simple but not easy. It's powerful, it's outside the system. It enables us to simply turn our backs, get on with our lives and stop feeding the beast. Combined with fair governance, fair justice and fair money, it opens the possibility of a world of abundance, peace and joy. What more could you ask for? So thank you for listening. There's more information below.